Hey guys, my name is Scott Shoemaker, and I am an estate planning attorney here in Cedar Rapids, Iowa. And it's almost, oh, I guess it is, it's past the end of the month of June, so I've kind of missed the Pride party, but it's been on my mind a lot lately. As the parent of a gay son, I think a lot about estate planning for same-sex couples, and and now, without getting too political, obviously, with the announcement, with Justice Kennedy's announcement of his retirement from the Supreme Court, the question of same-sex marriage, I think, is on a lot of people's minds, and whether or not the Supreme Court decision that allowed same-sex marriage, whether or not that will stand, which underscores the importance of careful estate planning by same-sex couples, because in a carefully crafted estate plan, we can achieve many of the same rights and benefits that are automatically conferred on legally married couples. And so, as an estate planning attorney, I always sort of prefer the belt and suspenders approach. So sure, I hope very strongly that same-sex marriage continues to be the law of the land. But if it doesn't, then I would encourage I encourage same-sex couples to approach their estate planning very carefully, and this requires a sort of a global look at estate planning through, of course, the use of a will as your basic tool for the transfer of property. You certainly don't want, because the law, if you don't have a will, does not recognize generally long-term life partners if you're not legally married. But if you are, then then you can go that way. But it's a big risk, and so at the very least, you need a careful will that names your same-sex spouse as your heir, as your beneficiary under the will. And you also want to craft documents such as a power of attorney for health care and other things that gives your same-sex spouse the power to make end-of-life decisions for you in the same way that would automatically be conferred on opposite-sex spouses. And other documents as well, children's protection plans and things that would name guardians, name your same-sex spouse as the guardian of any minor children that you might have in the event of some sort of catastrophic incident, incapacity, or death. So you can take a lot of steps through careful estate planning that would lay the foundation for your relationship, for a same-sex couple's relationship, to reap a lot of the benefits of an opposite-sex married couple, even if the Supreme Court were to reverse itself. Certainly we hope that's not going to happen, but like I said, belt and suspenders, right? There are unfortunately ways that you can't quite get there. There would be tax consequences for the transfer of property between unmarried persons typically, and this is the whole Windsor v. United States case, right? That invalidated certain portions of the Defense of Marriage Act for federal tax purposes. And I don't know if we would go that far. I obviously don't have a crystal ball, but the bottom line is, through careful estate planning, same-sex couples can achieve at least a certain level of security, knowing that their wishes will be carried out in relationship to one another in a similar way to the way the wishes of opposite sex couples would be carried out. And I encourage you, if you're in a same-sex relationship, to take this very seriously and to go find an estate planner, an estate planning attorney that has knowledge of issues surrounding same-sex relationships. And again, I always thank you all for listening and wish you the very best. And we'll talk again soon. Thanks.